Welcome. The Court of Appeal of Guyana. Hearing of appeal in CCJ Consolidated Appeals GYCV number 1 of 2021 between Guyana Geology and Mines Commission and BK International Incorporated and Chunilal Babulal, and GYCV number 3 of 2021 between Chunilal Babulal and BK International Incorporated and Guyana Geology and Mines Commission. This morning's panel comprised your honors, Mr. Justice Saunders, President and Presiding Judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Mr. Justice Barrow.
Good morning, all.
And Mr. Justice Jamada.
Good morning to everyone.
May we have the appearances, please? Thank you.
If it pleases Your Honors, Nikhil Ramkaran and Ms. Rebecca Khan for GGMC, the appellant in 001-2021.
Your Honors, I am C.V. Sakram and I appear together with Mr. Rupnarang Sakram and Mr. Ron Motilal for the appellant Sunilal Babulal.
May it please Your Honors, this is Robin Stobie. I appear with Mr. Edward Lacou for the respondent, BK International Inc. in both of the matters. Good morning, Your Honors.
Yes, good morning again, Council. Good morning to you all. We had agreed that we would allot 60 minutes, an hour to GGMC, to Mr. Babulal, then to BK, and then I think that there is a 15-minute rebuttal on each side. Mr. Ramkaran, are you ready?
Yes, please, Your Honors. I hopefully will not require all that time as I intend to be quite brief,
Yes.
but I am ready to proceed with Your Honor's leave.
Please do.
Your Honors, I wish to note, firstly, that we are relying on our submissions in writing before this Honorable Court and before the Courts of Appeal and the Lower Court in Guyana. We will also, for wherever our submissions do not address issues that the court considers meritorious, we are going to rely on the submissions of Mr. Satram, or Messrs. Satram, rather. Essentially, our position in this matter is grounded on one issue mainly, and that is whether or not GGMC is a procurement agency or procuring entity under the provisions of the Procurement Act. It is our position, which we state at paragraph 2 of our submissions, or begin at paragraph 2 of our submissions, that this is in fact not the case. Now, we believe that there has been quite a substantial mountain made out of a molehill by learned counsels for the BK International regarding many aspects of judicial review as it applies to this matter. Quite a lot of it in our respectful submission are not particularly relevant to these proceedings as they relate to in great measure whether or not GGMC is subject to judicial review. We will confine our arguments, and we hope to convince this Honorable Court that whatever other remedies may apply, that GGMC is not a procurement agency. Now,
Counsel, it's not
yes,
a procurement agency, it's a procurement entity.
My apologies, sir. That is correct. We are contending that it is not a procurement entity. The main thrust of our argument is founded on the findings in Rafferty, which it is, I believe, or I submit, or we submit rather, that notwithstanding the learned then Chief Justice, Mr. Ian Chang's attempt to distinguish Rafferty, his arguments do not support the conclusion. Now, Mr. Chang, then Chief Justice, went through a number of authorities in his ruling, beginning at page 270 of the record, and continuing, where he delves deeply into a number of authorities that he refers to in his decision. And eventually comes to the conclusion that having regard to the level of executive control exercisable by the Minister of Natural Resources, that GGMC must be a statutory agency of the Ministry of Natural Resources and Environment. Now, I do not know what the learned Chief Justice, as he then was how he was drawing the link between this finding that GGMC must be a statutory agency and drawing this into the Procurement Act to form the conclusion that GGMC is subject to the Procurement Act. And it is our respectful submission that the learned Chief Justice's reasoning does not support that conclusion. The reason that this is important to our considerations, or at least in our submissions, is that the Procurement Act is proposed in these proceedings to govern the tendering and acceptance of a bid that was made during a process. I'm sure I don't have to go through the history of the facts to your honors, who I know read these things very deeply. Now, if the Procurement Act does apply, then the considerations or the conclusions that were made by Justice Ian Chang could not be challenged. However, given the circumstances, first, and it's noteworthy that there's been very little reference.
Mr. Ramkaran, I just want to be very, very clear about what you just said. Are you saying that if the Procurement Act, in this case, apply to GGMC, then you cannot find fault with Chief Justice Chang's reasoning and outcome on this point?
Mr. Justice Chang was very, very detailed. I do not believe that I can fault his reasoning apart from this issue. The problem that I have with Justice Chang's reasoning is that he reaches a point, having dealt with a number of cases which suggest that in circumstances like these, the agency, GGMC in this case, or the entity, GGMC in this case, are not, when they tender out, this is a private transaction. He dealt with a number of cases that, that go into this issue. He then makes a leap, which I do not understand, which for our submissions, we're saying is not supported by his reasoning prior to making the leap. And he says that by some mechanism, this means that the GGMC is a procurement entity. And this we're saying cannot be supported. There are no circumstances that I can see, certainly having regard to the cases that I've read, the cases that Justice Chang referred to, and the cases my learned seniors for BK International referred to, where the conclusion can be supported that in some manner the GGMC is a procurement entity. Now, my learned friends have gone through a significant amount of cases in their submissions.
Go to those cases, Counsel, just to be clear, because this is, I think, an important point. Are you saying that you're not contesting that GGMC is a government agency?
No, sir.
Okay, and you're not contesting either that it is a statutory agency?
No, sir.
What you are contesting what you are contesting is that it is a procurement entity as defined in the Procurement Act. Is that it?
It's not a procurement entity, yes, sir.
Okay. Just now, Mr. Ramkaran, this is at variance with your submissions, isn't it? In J of your submissions, that's 2J, is it? I understood you to be saying that GGMC cannot be a procurement entity because it is not a department, agency, or other unit of the government. But now you're saying that you accept that it is an agency of the government, but notwithstanding that, it is not a procurement entity. I'm a little confused.
Your Honors, I do apologize. That appears to have been a misstatement on my part. They're not an agency of the government. They're a public company. There is an act which establishes the GGMC.
Okay,
sorry, Counsel, do you need to go that far? Because aren't you looking at the definition of procuring entity in the Act?
One moment, sir.
That definition speaks to the procuring entity of any ministry, department, agency, or other unit, or any subdivision thereof of the government.
Yes, sir.
So if I understand you correctly, well, now I'm not quite clear what you're saying, but I thought initially you were saying that they could very well be an agency of the government or a statutory
no,
agency,
Sorry.
but they were not a procuring entity of the ministry or the government, etc. I thought that's what you were saying.
I think my mind is going a little faster than my words, please, Your Honors. GGMC is not a government department, it's not a government agency, and it's not any other unit of the government.
And for that reason, it cannot be a procurement entity. That's your argument.
And for that reason, it cannot be a procurement entity. Yes, sir. I apologize if I
on this, Counsel. Is it possible that an entity could be a government agency and still not be a procuring entity?
Is it possible that an agency can be?
Is it possible that GGMC, for example, could be a government agency or a statutory agency, but still not a procuring entity?
Well, the Procurement Act specifically uses the words government agency. So I would not agree that an entity can be a government agency and still not be a procurement entity.
Okay.
That type of organization, which is not GGMC, going by the strict definition in the Procurement Act, would have to be a procuring entity, a procurement entity. Okay, so the Act is very clear with its language.
Yeah, I'm very clear now on what you're saying. Thank you.
Thank you, sir.
Counsel, before you go further, my brother is very clear.
Yes, sir.
I am also, but I want to be 100% clear. The note that I have written down is that once it is an agency, it has to be a procuring entity. Is that correct? Once it is an agency, it has to be, and it is procuring, then it has to be a procuring
entity. Sir, I'm not hearing you.
Yeah? Okay, let me repeat. As I understand it, you are saying, in essence, that once...
my apologies, Your Honor. You broke for a minute or so there.
And I am going to repeat.
Thank you, sir.
I understand you to be saying that once a body is an agency, then it has to be a procuring entity. Is that correct?
Once it is engaged in procuring. Once it is engaged in procuring, right?
Well, yes. No, but our brother added a new element there. Counsel, maybe you want to look at the definition and take us through it, because that might be important. The definition in, where is it? Section 2 of the Act, where it speaks about the definition of a procuring entity.
2L.
Thank you, President. Yes.
One moment, please, Your Honors.
2L.
Your Honor, Your Honors, I seem to have misplaced my copy. Just one moment, please. Yes, sir. Yes, sir. I'm with you on that. Means the procuring entity of any ministry, department, agency, or other unit, or any subdivision thereof of the government that engages in procurement.
Okay, was the GGMC engaged in procurement?
It is engaged in procurement, please, Your Honors.
So the critical issue is whether
but it was engaged.
The critical issue is whether it is an agency of the government. Would you agree?
Yes, sir.
And it is your argument that so this particular question can be reduced to whether the GGMC is an agency of the government. Is that correct?
Pardon. We seem to have lost one of our devices.
Okay. Are you hearing me now?
Are we?
Yes, I'm hearing you. Are you hearing me?
Are we coming through?
I am hearing you. Are you hearing me? Mr. Ramkaran? Mr. Ramkaran, are you hearing us? I think we have lost him for a while.
Councillor, are you hearing any of us? Mr. Ramkaran?
I think he's fallen off.
Seems to me that we need assistance from the IT.
He fell off.
My apologies, Your Honors. Are we back on the call?
You're back on the call now. Are you hearing me? Are you hearing me? For some reason, we are hearing him, but he is on. You're on mute now. Mr. Ramkaran, if you're hearing me, you're on mute. It's showing that you are muted.
President, he placed a message in the chat. I will try to see what's happening with whether Paul can assist him. He says he's
now unmuted, but
okay.
My apologies, Your Honors. Are we back on? Can you hear us?
I'm hearing you. Are you hearing me?
Yes, sir.
Okay, you were muted a short while ago. Before you fell off, I think we were getting to narrow this particular issue. And we agreed that the GGMC it engages in procurement. And therefore, the critical issue to determine whether it is or is not a procuring entity is whether it can be properly described as an agency of the government. Is that correct?
That is correct.
And your view is that it is not an agency of the government.
That is correct, sir.
It is a private body.
That is also correct, sir.
It does what it has to do.
And
it does what it has to do on its own behalf for itself. It doesn't do it for the government.
Policies are made by the government, and this is the basis of GGMC's activities, or this forms the basis on which GGMC acts.
When it carries out its work, does it carry out that work for its own self, or does it carry out that work for and on behalf of the government?
Your Honors, the policy activities, the overall policies are it executes the policies in a manner in which it determines is best. I do not agree that for the terms of the government agency set out quite clearly in Rafferty.
Mr. Ramkaran, before you go to the case,
yes, sir.
Can you go to this commission is established by Act of Parliament, is it?
Yes, sir.
Would you agree, therefore, to answer the President, that if we have to look to discover the character, powers, nature, funding, etc. of this entity, we should look to the source document first?
Yes, I do agree, sir.
All right.
Sure.
So if we look at that document, the President asked you, does it carry on its work for itself on behalf of the government? Paragraph section 6. What is the source of funding? Well, first of all, look at what the mandate is. Look at section 4. That function of the commission, is that a function that is being done in relation to state resources in Guyana or private resources that this company owns or controls and can do with as it pleases?
Just give me 1 second to switch back to the other machine. Apologies for the interruption. Apologies for the interruptions, Your Honor. Yes, Your Honor. To answer that question directly, the resources that GGMC utilizes in the execution of its functions are sourced from the government and from individuals who make use of its services and pay fees. So it's not a private.
Are those fees retained in the coffers of the company, the authority, or are they paid into the consolidated fund?
They're paid into the consolidated fund. If my knowledge of government, these types of entities are any indication. I'm not entirely certain if there is a difference in GGMC, but I do not believe so. Those funds would be paid into the consolidated fund.
Can it borrow without ministerial approval and fiat? Section 7.
Well, sorry, before you go to section 7, my brother, the other things in 4.
Yeah, of course,
I'm really troubled, Mr. Ramkaran, by all of these things, which it seems to me, subject to your correcting me, are the clearest possible indication that what the Commission is dealing with are assets, resources of the state. So that, for instance, looking at subsection 2, 4 subsection 2, without prejudice to the generality of subsection 1, the Commission may, and then A, convert, remove, and sell by auction or tender or in any other manner whatsoever minerals or mineral products from state lands. Now,
That is correct, sir.
Mr. Ramkaran, how could any private entity for its own self sell the national minerals?
I hope I was not interpreted as suggesting that, please, Your Honors. I do not. These assets and...
No, fine, you are not. You are not. So then you are left with that. And then look at B, 3B. The Commission shall be responsible for the collection and recovery of all rents, fees, royalties, penalties, levies, tolls, and charges payable under the Mining Act and any other revenues of the Commission. So they are collecting revenues which are due to the state.
Yes, sir.
Therefore, those revenues remain the property of the state.
That is correct, sir.
Mr. Ramkaran, why is it not therefore a fortiori they are an agency of government? Because that's the discussion we are having. We're having, first question is the GGMC a government agency? You say no. If they're not a government agency, you said to us, and I have written it down, it is a private entity. What our brother has, I think, asked you and you have accepted is, it's doing all these things for and on behalf of the government and people of Guyana. Why do you say that does not make it an agency of government?
Before you answer that, Mr. Ramkaran, let me add on to what my brother just said. 31.7 is where you had some diffidence. 31.7 the diffidence. Any direction under subsection 6 may require the whole or any part of the revenues of the Commission to be paid into the consolidated fund. Now, there is just absolutely no way that any private entity's revenues could be required to be paid into the consolidated fund.
You're correct, sir. I'm not disputing that.
Okay, well, I'll tell you what, Mr. Ramkaran. We have your arguments,
yes,
submissions. I want you to proceed. You only have another half an hour or so. I want you to proceed with your submissions on the basis that the GGMC is in fact an agency of the government.
Thank you for that, President. I'm sure that Mr. Ramkaran will accept accordingly. So with that acceptance, could we go back to section 6, please, of the Procurement Act? Because I'm still a bit troubled by the answer you are giving coming out of section 6, which defines who a procurement entity is. I assume, Mr. Ramkaran, that the definition is important because it is the procurement entity that is caught by the provisions of the Procurement Act. Am I right?
That is correct, sir.
Sorry, what is on the screen is the GGMC Act, not the Procurement Act.
Yes. So we need to go back to the Procurement Act. Keep this one handy as well, though, because I'm interested in the provisions there too. But just to go back for a minute to section 6. And I'm a little puzzled and troubled because the way you seem to be willing to interpret the definition would seem to render useless certain words used in it. And I'm a little curious about that. So procuring entity means the procuring entity of any ministry, etc., that engages in procurement. Now, the way you're interpreting it, as I understand, or willing to interpret it, is that the words "the procuring entity" in the first line there are not there. Because surely, in order to benefit or to come within the definition of the procuring entity, the entity we are talking about must be the procuring entity of the ministry. So it can't mean that procuring entity means any ministry, department, etc., that engages in procurement. Surely it has to be the procuring entity, I'm asking, of the ministry, department, etc., that then qualifies.
Your Honor, I agree with that entirely.
Okay.
It says so quite clearly. I can't, I won't go against the clear meaning of the definition.
Right.
It
So
is the procuring entity of any.
With your earlier counsel, can't you concede that your client is in fact an agency of the government and still say it's not a procuring entity? I mean, the president has pressed on you, and you seem to have accepted that GGMC is in fact a government agency, and I don't think there's any doubt based on what has been said this morning that it is. My interest is in finding out whether it is in fact the procuring entity of any ministry, government agency, or the unit or subdivision of the government. And for that purpose, I think we need to go back to the Act, and I need to be located in the provision which defines GGMC as such a procuring entity. Where in the Act does it indicate that GGMC is in fact a procuring entity? The word tender is used, I believe, in one provision, so that could be relevant.
I beg your pardon, sir?
The word tender is used in at least one provision, section 4(2)(a). So I'm not sure if that is where the definition of GGMC as a procuring entity would come in. But I'm just wondering whether you could assist in assuming that we are to give some meaning to the first line in the definition, how it is that GGMC is legislated as a procuring entity. It has a lot of functions, of course, very important functions for the mining industry in Guyana, but I'm just wondering where it is designated as a procuring entity.
Your Honor, as far as I can determine from the acts and the cases that I've read, the GGMC is not a procurement entity. I mean, I don't want to belabor that that statement, but I have not seen any provision of the GGMC Act, the Mining Act, the Procurement Act, or anything else that suggests that GGMC, for the purpose of the Procurement Act and for the purpose of the definition stating in therein of procuring entity, that GGMC is that.
Okay. So in other words, assuming that the GGMC is an agency of the government and engages in procurement, it can just bypass the Procurement Act because there is nothing in the statute that establishes it that says you are hereby declared or determined to be a procurement entity. Is that your argument?
Yes, essentially, sir. The GGMC is a body corporate as established by its own act. So I do not believe that as far as the definition in the Procurement Act states what a procuring entity is, that GGMC is not that.
Well, okay. I want you to proceed with your arguments because your time is running down. If it is not a procurement agency, if it is not a procuring entity, then of course there is no basis upon which one can say that it is bound to follow the statutory provisions of the Procurement Act. Is that correct?
That is correct, sir.
And that is perhaps your principal argument?
Yes, sir. It is my principal argument that this tendering process is a private transaction.
Right. Whether you have a backup argument. Let us assume that we disagree with you and we find that this is an agency of the government. This is an agency that engages in procurement and therefore has a statutory obligation to abide by the Procurement Act. Then what?
Well, Your Honor, then Your Honors, I would then rely on the additional aspects of the merits of the application itself that was made by BK International. Sorry, not the application, the tendering process. It is our position that the tendering process was not breached. So even if this Honorable Court does find that the GGMC is a procuring agency for the purpose of the Procurement Act, then we would argue that there is no aspect of the process that took place that is now being challenged, or that was previously challenged, that breached that process.
Tell me
so
something.
They were compliant.
Was an advertisement posted in a newspaper of general circulation inviting the public to pre-qualify?
Not that I'm aware of, sir. Invitations were issued to the entities and individuals who were determined previously to have pre-qualified.
And the process of determining that process of determination, I think that is what Mr. Justice Chang called a mystery. That we don't really have much information on that process. Is that correct?
That is correct, sir. The issue of the pre-qualification was not. It's an issue that was Justice Chang, if I'm not mistaken, determined that was an issue. I am not aware of anything in the affidavits that, which is the evidence that Justice Chang relied upon, that specifically speaks to that process.
Mm-hmm.
So as far as you're aware, you said you do not think or you do not know that there was in fact a general advertisement to the public. Now,
I'm not aware of that.
You're not aware. Assuming that there was not, and assuming that you came within the Procurement Act, would you say that the failure to have that public advertisement was in fact a breach of the procurement procedures?
One moment, sir. I'll be entirely candid, sir. I did not look at the matter with that consideration in mind. Certainly, I think that that there are other issues that are required by procuring entities to go through that were not done in this particular case. But that is because the GGMC at this point in this matter and previously along the lines of all the other entities or agencies or whatever it is, all of the body corporates that were incorporated by the government, including the GRA, the Revenue Authority, GGMC, and others, they have always proceeded on the basis that the Procurement Act does not apply in circumstances where they are tendering for a private insofar as the relationship between the entity and the contractor is concerned.
Sorry, is that in evidence somewhere, Counsel?
I beg your pardon, sir?
Is that in evidence somewhere that all of these entities that you mentioned have all proceeded on the basis that they are not bound by the Act?
It's not in evidence in this matter, sir, but the cases that are referred to, including the Guyana Power and Light, or as it was known in the past, beg your pardon, sir. The cases that are cited by Justice Chang himself and cases that were cited by my learned colleagues, Satram, in their arguments, they established that these are considered private agreements, not subject to the Procurement Act. So not in evidence, but certainly in the cases that are referred to.
All right.
I mean, there's another line of argument, of course, Counsel, available to you, arguably from Section 6 of the Procurement Act, which makes the process sort of discretionary. So that even if you were to be, in fact, a procuring entity, the word may is used in Section 6.1. I
see
don't
that,
know
sir.
if that would be useful or helpful to you.
It is helpful, sir. I think that this does make it a discretionary process, the pre-qualifications, that is.
Okay.
That is, of course, sir, if we determine that the Procurement Act does apply in this case.
Yes, yes. No decision has been taken on that, but arguendo, as I gather some of our colleagues say in some jurisdictions.
Yes, sir.
Yeah.
Your Honors, let me just conclude by saying, unless Your Honors have some other questions to put to me before I do that, that if it is determined that there was a flaw in the tendering process, if it's determined by this honorable court that there was a flaw in the tendering process, we are amenable to redoing that tendering process and having it proceed again. Our main, I know my learned friends, Mr. and Mr. Satram, will severely disagree with that, and I understand their disagreement and the nature thereof. But if this court finds that there was a process sufficient to set aside the tendering process that was done in 2013, I think it is 2012 or 2013, we would have no difficulty with that. Our only difficulty is that while we had voluntarily observed some of the provisions of the Procurement Act, we do not believe that it applies to us as an agency, or not as, I should not use that word, as defined by the Procurement Act, sir.
So tell me something. The road has not been done. I mean, they did about 9–10% or a little less than that, I think. But the rest of the road is still there in need of repairs. Since 2013, it must have gone into greater disrepair. Is that the case?
I believe that that is the case, sir. I'm relying on my learned friends, the Satrams. Perhaps I can just refer to them as Satram. Mr. Satram has indicated that subsequent to their clients' work on the road, and I believe prior to the order granted by Justice Chang, there has been no work on the road or no tendering for any contract to continue working on the road.
Okay, but let me ask you something now. If it is that the GGMC is not a procuring entity, and if it is that the GGMC can willy-nilly simply handpick, and I'm not saying that this is what happened here, but I'm saying that this is the natural, logical consequence of the arguments I've seen, can simply, handpick persons to do various things what essentially are state assets. Don't you see a difficulty with that, or does that sit well for transparency or accountability?
Your Honor, that's an interesting question, and I believe that there is a process set out in the GGMC Act, if I'm not mistaken. My learned friend Satram have referred to it. There is a process that any person who is aggrieved by the tendering process can adopt and receive adjudication on the issues. This process was not accessed by the BK International, and there is a lot of argument from my learned friends that they are entitled. Now that has gone out, that is all moot now, because the Judicial Review Act specifically says that notwithstanding the availability of other remedies, you can still go to judicial review. I'm not suggesting anything contrary to that, but
Mr. Brown, could I just pause for a minute, because that's very important. Sure. for me. Is it your position is that the 2010 GR Act, which came into force in, I think, 2019, that does not apply in this case because the contract was in 2013. Is that your position, that the GR Act does not apply?
No, sir. No, sir. I'm simply saying.
No. Is your position that the GR Act applies or does not apply in this case?
Your Honor, we are not disagreeing that the Act can apply. I know I'm being very equivocal here, but this is as far as I can see. But we're not taking...
That's fine. That's fine. I'll take your answer. I don't want to press you beyond what you're willing to say or accept. That's a question of law in part. Never mind that. I just want to follow up before you keep going on what the President asked. Under Section 4 of the Act, the GGMC Act, the functions of the Commission, and our brother Justice Barrow raised on this. 4.2c, without prejudice to the generality of 1, the Commission may A, convert, remove, and sell by auction or tender or in any other manner whatsoever minerals or mineral products from state lands. And that is gold, silver, oil, everything. Agreed?
Yes, sir, I do.
Good. You said earlier that the case law suggests that where contracts are considered private, that the Procurement Act does not apply to tendering. That's what you said a few moments ago. Right. Are there any kinds of sales, auctions, tender, or any other kinds of such relationships, because that is obviously you just generous, that the Procurement Act may apply to in relation to the GGMC? Or is it your position that the GGMC, in relation to all of what it can do without any reservation, is not subject to the Procurement Act? So, for example, it can, without pre-qualification, without advertisement, pre-select 2 companies and say bid for the gold in the whole of Demerara.
I don't believe that.
Now I'm asking you because we have to test the hypothetical. Is there any limit to your submission that what you say, what are considered private contracts are not subject to the Procurement Act? Is there any limit to that? Because under the Act, you can, and I've just raised one, B is construct roads, transport minerals, but I'm looking at A because A is the sale of minerals. In other words, forget about transporting and building roads. You may say that's ancillary, no problem. I'm asking you about state resources. Can GGMC, without a public procurement process, sell the gold in Demerara by private contract to who it determines it wants to? Is that your position?
No, sir, it is not.
Is that subject to the Procurement Act?
No, sir, it is not. It is subject to GGMC's own processes and regulations, the mining regulations, and this section itself, although it does go on to say in any other manner whatsoever, it does refer to auction and tender.
So what is the limitation? So in other words, in relation to all minerals and mineral products for the state of Guyana, which are its biggest asset, certainly in relation to hydrocarbons right now, correct? It is not subject to the Procurement Act, which was brought into place to bring accountability, transparency, etc., etc., etc. That's a government, by creating a corporation, which is let us assume it is a government agency acting for and on behalf of the government, but in a privatized form for efficiency, is now exempt from the Procurement Act, which was passed by its short title. To do what? What is the purpose of the Procurement Act? Why does Guyana want a Procurement Act? To protect who?
Your Honor, the most direct response I can give to that, although it's not in issue in this matter, is that those interests are all protected in the Mining Act and the mining regulations, which govern the operation of GGMC and the procedures that are required before any of these activities can be taken. The GGMC Act itself does not go into those details because that would be outside of the ambit of its operation. The acts that require that cover the issues of transparency and due process are the requirements. Sorry, not the act. The requirements. Those requirements specifically that Your Honor referred to are all in the Mining Act and the mining regulations,
and
including
those are, in other words, when the Procurement Act was introduced, the Mining Act was long in existence before that, wasn't it?
Yes, sir.
Yeah, those sufficiently cover what the Procurement Act seeks to do. Is it that those old mining acts provided for the processes to be followed to ensure transparency, accountability? I'm just asking. I mean, I will look it up myself. I haven't looked at it. I will look at the Mining Act and see whether it has built into it all of these checks and balances. Does it?
It does, sir. The Mining Act and the mining regulations, sir. The regulations made under the Act.
Good, thank you.
I'm sorry. Yeah, can we just come back to something we were discussing a couple minutes ago? I think in reaction to a question asked on the bench about the question of judicial review and the availability of it in relation to GGMC. Now,
yes, sir.
Let us assume, arguendo, that GGMC is a government entity or agency, but not a procurement agency or entity. Yeah. So you're saying in that scenario that your client, GGMC, would not fall under the provisions of the Procurement Act?
Correct, sir.
Okay. But would you also concede that even in that scenario, GGMC would fall under the ambit of judicial review, given that it is, in fact, a government entity?
Your Honor, I'm not sure if we've ever challenged that position, but certainly in the recent past that I'm aware of, we have not.
Yes, because
that GGMC is amenable to judicial review.
Okay, so that I assume then that in relation to, say, a judicial review action, if GGMC engaged in the activities of a procuring entity, when it is not. That those activities would fall outside of its jurisdiction. Am I right or not?
I'm not certain I understand you, sir.
You are suggesting that GGMC, whilst a government agency, is not a procuring entity.
Correct.
If it is not a procuring entity, then I assume it ought not to do the things that a procuring entity would do.
It's not required by the Procurement Act to do so.
Now, I'm not sure which direction you went in there. But you are conceding in one breath that GGMC is not a procuring entity. And I'm just saying that if you concede that, or if you allege that, then you would agree that GGMC cannot lawfully do the things that a procuring entity is able to do.
I see the distinction that you're making, sir. Any positive act that the Procurement Act requires can be voluntarily accepted by the GGMC, and that's what they did in some respect in this case. They're not mandated to do so, and they are not, if they breach aspects of the Procurement Act, they're not subject to the corrections in that act.
Is this the first occasion that the GGMC was dealing with tendering and procurement issues?
I can't answer that question as I don't have that knowledge, but given the circumstances, I doubt very much that it was.
I see. Okay. In the absence, unless anyone has any further questions, and unless you yourself have any final submissions, then I wish to thank you for your oral submissions. Of course, we do have your written submissions and the authorities, and we will naturally advert to those as we deliberate on this matter. So thank you very much, Mr. Ramkran.
Thank you, Your Honors.
Yes. Mr. Satram?
Good morning, Your Honor.
Yes, good morning.
Your Honor, about 8 years ago, the High Court in Guyana made an order effectively invalidating a contract which was awarded to our client for road works to be done in Mazaruni. The contract had been part performed at the time it made that order. About 20% of the works had already been completed. Chief Justice Chang felt that the best way to deal with that event was to direct that Babulal be paid for the work he had done on the road. He directed essentially that payments were to be made on the contract which he found to be void. Now,
sorry, Mr. Satram, I have been troubled by that. Did he direct that payment was to be made under the contract, or did he direct that payment was to be made on the basis of a quantum merit?
Quantum merit, I thought so.
Couldn't be out contract. What entitled him?
No, hold on. Before you question what entitled him, I want to get the factual statement correct. You said he directed that it was to be made under a contract that he found invalid. I'm trying to get clear whether that is what he did. I do not know. I'm asking you.
Well, he said quantum merit.
Okay, thanks.
The effect of what he did was to direct that payments be made for works which were done pursuant to a contract. Because at the time the works were done, contract was in effect. Now, the courts below, Your Honors, gave no consideration the consequences of their decision, which was bound to produce delays in the completion of the road. And the result of that is that the road has not been rehabilitated today.
Let me interrupt you for a different purpose now, Mr. Sakram. The point that I think everybody makes is the vast delay that has been engendered. Real question is, can this contract now be performed meaningfully in the sense of the price which was quoted 8 years ago, etc.? So that is a question that does not need to form part of your submission, but it is for me an interesting background question when we think in terms of all aspects of the remedy. So can this contract, just your own view, now be, can we, for instance, say, okay, we find that the contract was validly awarded and it shall now be carried into force?
And is that what your client wants?
Yes, sir. That my instructions at this moment is that he's willing to complete the contract.
On the same terms and conditions as before?
On the same terms and conditions. Those are my instructions.
Yeah, can I just join my brothers, Mr. Sakram, in expressing some incredulity at what has happened. And I'm always perplexed when I'm faced with these kinds of scenarios, as again, I'm facing this case. We were talking about 8 years delay in completing what I think your submissions refer to as an emergency measure. And the impact that has had, I imagine, on economic life and the prospects for economic development in Guyana. I just find it quite incredible that we are here at this point. And this is part of the reason I want to go into perhaps to the other side, the question of the use of administrative review rather than judicial review. But we no doubt we'll get to that. But can you just explain in a couple of sentences the context of why this was regarded as some kind of emergency road relief program?
There is some evidence in a report, I believe of the Special Projects Unit, which suggests that there was some form of protest or complaint that were raised with the government or the minister at the time regarding the state of the road. And that is what led to the decision to rehabilitate the road.
Okay.
But picking up on what Your Honor just said, Your Honor, there can be no doubt that the public has been denied the full benefit of the use of that road. And that will remain true whatever is the outcome of this process. And what is also true is that this process, the judicial process, will not reveal the true harm that may have been caused by this denial. But, Your Honor, our position can be summarized briefly as follows. One, we say that there was compliance with the terms of the invitation for bid, contrary to what is alleged by BT. In other words, there was no non-compliance, and I will develop that shortly. We say, secondly, that assuming that there was non-compliance, we submit that it was not substantial enough to justify quashing of the contract. And thirdly, we say, assuming further that there was non-compliance and that it was substantial, that the relief sought should have been refused on a discretionary basis because of three reasons. One, because there was an adequate alternative remedy either in contract or if the Procurement Act was applicable, then under sections 52 and 53 of that Act. Two, it should have been refused because the decision was not amenable to judicial review, and even if it were so amenable, there are no grounds for the review. And thirdly, we say that the relief should have been refused on a discretionary basis because the contract had been part performed, and setting it aside was a disproportionate remedy in the circumstance. Now, I'd like to begin by interrogating the allegations of non-compliance. There are basically three complaints raised by BK, and they can be found at page 103 of the record, at paragraphs 20, 21, and 22 of his affidavit in support of the motion. And those complaints are also repeated at paragraph 33 of his affidavit, which is at page 106 of the record. And the complaints are these, Your Honor. A, that CB&R did not submit NIS and GRA compliances as required. B, that CBR did not submit information as it relates to general experience, personnel, equipment, etc. And C, that CBR had no legal status, that searches were conducted and it revealed that CBR does not exist. Now, the invitation to treat, which is at page 142 of the record, says that bidding will be conducted through the national competitive bidding procedures specified in the Procurement Act. The GGMC exhibited, Your Honor, standard bidding procedures in accordance with which the bidding was conducted, and they are at page 138 of the record. And the exhibit also contains the bidding data sheet, which is at page 164 of the record. Now, that document, the instructions to bidders, says it complies with the provisions of the Procurement Act. And you'll see that statement at page 139 of the record. And it says further at page 145 that it shall not form part of the contract. I suppose it was saying there that the terms are to be regarded as terms of the invitation to treat. But the point is this, Your Honor. It is clause 5.3. And I invite Your Honor to look at that clause at page 149 of the record. It is that clause which requires evidence of status, evidence of experience, machines, etc. Nothing in there requires compliance. BK claims at paragraph 17 of its affidavit at page 102 that clause 5.4 was modified by the data sheet to require compliance. The data sheet is at page 164, Your Honor. There is no such statement or modification in the data sheet at 5.4 at page 164 of the record. That is simply not true. Nothing in the data sheet requires compliance. If we go back, if we go to 5.3 of the data sheet at page 164, Your Honor, you will see that it says that there are no modifications to that section at page 164. Your Honors will see, importantly, at 5.3, clause 5.3 at page 149, that clause 5.3, which requires all these things which BK say wasn't submitted, applies only if no pre-qualification was undertaken. Now, BK contends, and then the Chief now contends, and the Chief Justice raised this in his judgment, that the pre-qualification which took place was not done in terms of the Procurement Act. But Your Honor, BK was selected, was pre-qualified in this case, and selected to bid because he was pre-qualified. No challenge, I searched the motion. There is no challenge in the motion, no allegation whatsoever that that pre-qualification process was flawed or not in compliance with the Act. There was nothing to respond to as it relates to pre-qualification, and we say it was not an issue. We say further that BK was in fact affirming that process when he asked the High Court in his motion for the contract to be awarded to him. There was a prayer in this case for a mandamus that the contract be awarded to him. So, and we make this additional point on that pre-qualification issue. Mr. Babulal was entitled to rely on that pre-qualification process, which was not challenged. He was entitled to rely on clause 5.3 of the instructions to bidders, which said that it did not apply to him, and therefore he did not have to produce those documents. How else can we look at it? The 5.3, they have all, including BK, engaged in a pre-qualification process, which there was no complaints about. The 5.3 of the instructions to the bidders is saying, listen, you don't have to submit these things if you are pre-qualified. What obliges Babulal to submit? That is unreasonable.
Mr. Satram, was there or was there not a pre-qualification process in this case?
There had to have been, Your Honor, because everything is pointing to that fact, but it was not explored as if there was a challenge to it. If there was a challenge to it, if there was an allegation that there was this sham pre-qualification process, that there was no pre-qualification process in accordance with the Act, there may have been answers to it as to what exactly took place. But from all the documentation, including the invitation tender, which is at 142, it all points to the fact that bidders were selected and only specified bidders were invited to apply. If you look at paragraph 2 of the invitation, it says it is open, bidding will be conducted, blah, 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 and it is open to selective bidders. And then if you look at paragraph 4 of the invitation for bid, it says that the invited bidders are CB&R, MMC, BK, and RNA. There was no open tendering. But how could we respond to that allegation if it was not made? CDMC could have produced information, documents to support that pre-qualification process, that it could say what exactly happened. And we are saying that BK.
But Mr. Satram, I don't understand something. Your client must know whether there was a pre-qualification process. I don't follow. No, I accept that maybe it was not an issue raised, but I do not accept that your client cannot speak to that, because if you reach the stage of pre-qualification, you must know, when I say you, your client must know whether something happened before that. Your client must know whether there was a public advertisement, and in consequence of which your client submitted what are the quote-unquote pre-qualification documentation, and then you move to what would have been stage 2. So I am struggling to follow your position that you do not know and GGMC may be able to answer. If you engage this process, your client must know what process your client engaged. Was there or was there not a pre-qualification process that your client engaged?
Your Honor, I don't know if I was not clear, but I'm not saying, I did not mean to say that he doesn't know whether there was pre-qualification and what that process involved. What I'm saying is that he was never asked.
I understand that. I understand you say that you've perused the documents carefully and it was not on the motion or an issue. So I am asking you, in this case, from your client's point of view, was there a pre-qualification process that your client engaged?
Yes, sir, yes. But of course,
it was in this case.
The details of it, for example, whether there was an advertisement and you responded to that advertisement and so on, that is not before Your Honor. This is not on record. If I'm saying, all I'm saying is that if BK brought this challenge, alleging that there was some deficiency in that process, it would have been a response which would have aided the court in determining whether or not there was some deficiency. That is why I began by saying that there were three complaints by BK. There's nothing else. And he prayed for two orders. An order to quash the decision to award the contract to our client and for a mandamus.
Yeah, I think we're following you, Mr. Satram. However, you're also saying that BK benefited from whatever pre-qualification process there was.
He went further than that.
Okay.
He went further than that, Your Honor. He was saying that, look, give me the contract.
Right. On the basis of the process that he had been.
Whatever process is employed, award me the contract. Of course, that remedy was refused, and there's been no appeal against that aspect of the decision. Now, Your Honor, the employer, as I understand the statutory scheme and instruction to the bidders, has an obvious power to require all or none of the information mentioned in clause 5.3 or at section 5 of the act, provided that the act applies. Now, BK is saying that all of it was required, but he himself did not submit all the information mentioned in those provisions, especially at 5.3, because when we look at the SEMCO report he relies on at page 206, he didn't submit information regarding litigation, which is required by clause 5.3i. He didn't submit information regarding the monetary value of previous works, which is required by 5.3b. Nor did he submit financial reports for the past 5 years, which is required by 5.3f. So the question then becomes whether he can assert non-compliance if he himself was not fully compliant. Are we dealing in degrees of compliance? Can we say that, can he be allowed to say that he was more compliant than our client?
But Mr. Satcham, putting him aside for the moment, because I understand you to be saying, and I could understand that, he benefited or took advantage, or he was not prejudiced by the non-compliance that he complains of. But that is him. What about the public? In other words, putting him aside, isn't the question whether these steps ought to have been taken and were not taken, and if so, whether in the public interest, the process should be regarded as being flawed. So let us put him aside for the moment, because admittedly what he wanted was to have his cake and eat it, to take advantage of the non-compliance, to complain about it successfully, and then to have the contract vested in himself. Well, the court didn't do that. So let's not belabor the fact that he was one complaining about the non-compliance. And let us really turn our attention to whether, in fact, these are aspects of non-compliance. And as you rightly said, if they are they insubstantial?
Yes, sir. Yes, sir. I appreciate the guidance. I'll move to the second point. I've just sought to establish that there was no non-compliance as a matter of fact, because the case, there is a complaint before Your Honor, and it is grounded on complaints which Your Honors must be satisfied are factual. So I've dealt with that. I will move to the second aspect of our argument, which is that let us assume that there was non-compliance. And the question on our submission is assuming that there was non-compliance. The alleged omission, the three omissions, had no bearing on, nor did they materially affect the cost or price of the bid.
But is that the right question to ask? Whether non-compliance had a bearing on the price?
In the language of the Act and the instructions to the bidder, the question is whether it has any relevance to the scope, quality, or performance of the works. I believe Your Honors will see that at page 158 of the record, that's clause 27.2. They say a material.
Are you referring, please?
I'm looking for, Your Honor, at the instructions to bidders at page 152 of the record.
Yes, which number?
At clause
13.
Clause 7.2, page 158.
158.
Yes, page 158 of the record, clause 27.2.
Yes.
Your Honors will see that it says that a material deviation is one which affects in any substantial way the scope, quality, or performance of the work. Are Your Honors with me?
Yes, I didn't hear you for a short period, but I'm hearing you now.
It says, if I may repeat.
Just Mr. Safran, before you go, now you're speaking about, this is a material deviation for the purposes of the contract, right? But this clause in the instructions to bidders is concerned about the content, the subject matter of the work, correct? The project.
Your Honor, as I understand it, it deals with the question of whether the bid was responsive or not, and should be rejected or considered.
Okay, so this is a material deviation from what the tender must contain then, not the scope of work.
Yes, sir.
Right, okay, good, yeah. Thanks.
Because it refers to specifications of the bidding document. And if you go on to look at 27.3, it deals with the circumstances in which a bid should be rejected as non-conforming or unresponsive. So the evaluation report that was put before the Chief Justice at page 173 of the record essentially establishes that the decision to award the contract to our client turned on the feasibility of two items in BK's estimate, which, in the view of the technical committee, constituted the bulk of the work. Now, those estimates, two estimates, were found to be 55% below the engineer's estimate. So, the compliance and status and so on, we do not see here on it the link.
Sorry, what page is this?
Page 173.
Thank you.
You see,
Yes,
last. So that is what, Your Honor, that is what the decision of the committee turned on these technical engineering considerations, and not whether BK CB&R was a business name or whatever. Those arguments. For that reason, we say that the matters raised by BK were not substantial. Your Honor, on our final third aspect of our argument, assuming that there was no non-compliance, and assuming further that the non-compliance was substantial, we submit respectfully that certiorari should have been refused on a discretionary basis. There was, for a couple of reasons, there was an effective and complete remedy under the Act, Section 62 and 53. It may have been a remedy of contract as well. And we make this point, Your Honor, there cannot be selective reliance by BK on the instructions, the bidders, and the Act and the regulations. If the Act applies as BK contends, then the remedy prescribed by the Act should be utilized. The regulations, Your Honor, Regulation 10.5, Regulation 12, and Regulation 30 sets out process which should be followed. I think it says that if contract has been awarded, a complaint must be made in writing within 7 days. The monies, I believe, should be lodged, and a decision should be given in 10 or 15 days. The entire process ought not to take more than 3 weeks. And the powers given to that committee under the Act are far wider than the powers conferred available to Your Honors in judicial review proceedings.
I find that that possibility very, very fascinating, because I'm always trying to see how efficiently these disputes and others like it can be resolved. So I'm very heartened that there is, in fact, a procedure in place. And like you, I was struck by the fact that there are very tight timelines to be observed, the objective here being to bring resolution to the dispute as quickly as possible. What bothers me, though, is the scope of issues which can be properly considered by this process. As you know, the first step is the procuring entity. And then I think within 5 days, Mr. Safram, the procuring entity has to make some decision, and then escalates up to the Public Procurement Commission or National Board. And if that is not, if it is not resolved there, yeah, it then escalates up to cabinet. So there's obviously a process disciplined by strict timelines, so that we don't have 8 years go by and the road is unfinished and people can't use the road to get development on the way. But as I said, I'm just trying to be clear on what can be covered by that process. Now, I think you, in discussion with the bench, suggested that the issue of the pre-qualification for the bids was not relevant in this case, certainly was not raised by your opponent. The opponent benefited from it. Okay. But in a different universe where it was in fact an issue, and the suggestion is that the procuring entity, or GGMC if it is not a procuring entity, did not engage in, say, the advertisement proper pre-qualification process. Are those kinds of issues amenable to administrative review as outlined primarily in sections 52 and 53 of the Act? Or are they so fundamental to the process that instead of administrative review, they have to go to judicial review?
Your Honor, if you look, the answer is that at section 52.2, where it says that the protest may pertain to the pre-qualification or tendering proceeding. It was meant to cover everything. 52.2 is at page 101 of our bundle of authority.
Yes. So if it relates to the pre-qualification or the tendering proceedings or the method of procurement.
So that Parliament clearly intended that that procedure is available for every form of challenge, every type of challenge as regards procurement. And it empowered the various bodies, including the bid protest committee, to grant almost any type of relief, including damages, suspension of the award, annulment of the award, everything. Far wider than the powers of the court in judicial review.
And if you're not happy with the outcome of that process, you could take it to judicial review, I imagine.
Yes, as always. For example, if you didn't get a hearing or you took something, they abused their power or something.
Now, did you raise this point, or did your client raise this point in the courts below? And if so, what was the response to that point?
Yes, please, Your Honor. It was raised in the courts below. The Chief Justice did not deal with it, as far as I can remember. Just let me check that. I was looking for it last night. He did not deal with it. The Court of Appeal did address it briefly at page 25 of their decision. That is at page 23 of the record filed by GGMC. They said simply that we have concluded, in the words of the Chief of the Court of Appeal, we have concluded that this does not bar this claim for judicial review. A protest to the bid protest committee could be seen as a form of appeal of the merits and the tender. But that could not be an accurate view of the statutory scheme at section 52 and 53.
Because it speaks about the method, right?
Yeah.
You can protest, for example, the method of procurement selected.
Yes, sir.
Yes. Yeah.
Now, Your Honor, you see, the difficulty is that we can't ignore that those remedies, because it undermines the act. It undermines the wishes of Parliament, which is that public work should not be hampered by a resort to lengthy judicial proceedings. And this
How do you
case,
respond to the point that judicial review is always a discretionary remedy and you can pursue it, notwithstanding you have other remedies available?
well, that is the submission we make, that all of this is part of our argument that the remedy should have been refused on a discretionary
basis, right?
Because I want to make this final point on what Your Honor just said on the discretion. We're saying that the remedy would have been disproportionate in the circumstance, especially because the contract was part performed. There was no possibility in this case of BK being awarded damages. I said there was no claim for that. The mandamus had been refused and it had not been appealed, so there was no possibility of him being awarded the contract. The only utility of these proceedings is to have the process repeated and more or less to have clear instructions about what documents and information are required. This is all that this process could have achieved. And I would like to refer Your Honor to what Lord Justice Moses in the English Court of Appeal Division of Fudge and Southwest Strategic Authority said, beginning at paragraph 67 of his judgment. The Honor will see that at page 723 of our bundle of cases.
Sorry, at what page?
723. He begins by quoting Lord Justice Judge in R.V. Brent ex parte Walton. The exercise, quote, the exercise of the discretion to grant or refuse judicial review, usually in this case certainly does, involve close attention to both the nature of the illegality of the decision and its consequences. Whereas there is overwhelming evidence that the effect of judicial review will not be limited to requiring the authority to repeat the process in the prescribed form, but will certainly damage the interests of a large number of other individuals who have welcomed the proposal and acted on the basis that they will be implemented. It would be absurd for the court to ignore what Lord Justice Scheinman rightly described as the relevant disbenefit. And then, end of quote, he goes on to, Lord Justice Moses goes on to say, this approach, well settled in the sphere of public law, is particularly important in this case. We acknowledge that the courts are concerned to ensure that public administration, particularly in a field as important as the National Health Service, should comply with obligations imposed by statute. Since we have had the opportunity to correct the erroneous legal view of the department, something has been achieved. But we recognize also that that opportunity has arisen in a case where the impact on the claimant and others receiving health services can only be described at this stage as minimal. Our conclusion as to the law has been reached at the cost of a disproportionate amount of time and energy exacerbated by the burden of files, etc. Public law falls into disrepute if it causes an unnecessary diversion of work and resources. It is dispiriting that we can discern little, if any, benefit to those in Avon, Gloucestershire, and Wiltshire as having established that the department erred in law in its view as to Section 11. So we see that in this case, if the process has to be repeated, there will be clearer instructions about whether compliance is required and whether proof of status and so on is required. And that would be it. In the meantime, the public was denied the benefits of that rule for 8 years.
8 years and counting.
And only God knows how much longer, because there's nothing to stop a further challenge to it, which may take another 8 years. Because there's no guidance on whether resort should be had to that bid protest committee. It may very well take another 8 years. That's a reality of litigation in this country. Your Honor, one final point, unless Your Honor have anything.
Mr. Satram, it's a bit ironic
Yes.
that you are suggesting that the better, the fair remedy is to allow this contract to proceed, because given the delay in the judicial system, it is the wiser course to follow.
Well, it's not only Your Honor, if there was a choice of remedy, Your Honor will have to decide that question. If there was a choice of remedy, there was a speedy remedy and effective remedy available under the Act, which BK is saying applies. And there was judicial review proceedings, which was bound to be lengthy. And it chose to pursue judicial review, and it resulted in the delay. Who's to blame for that? You see, we can't, as Justice Saunders had said earlier, we can't be focused on Babulal and BK alone, who are the competing bidders in this case. We must look at the program of the government, the benefit that this thing was intended to achieve. Nobody knows how much harm was caused. Your Honor, those roads lead to mining districts where people can carry out mining every day. We don't know how much earnings were lost, what economic impact it had on their lives, etc. How many people were put out of business as a result of this delay. And on the point of whether the Procurement Act applies, as far as my experience goes, these public corporations and government-owned companies, like NISIL and so on, do not generally consider themselves bound by the Procurement Act strictly. They do rely on these standard bidding documents and so on.
Why do they not regard themselves as bound?
Perhaps because of the reason because of the way they construe the Act. But the point I wish to make, Your Honor, is that once Your Honors decide, if Your Honors decide.
Sorry, I'm not, with respect, I'm not sure I'm happy with that. You say it depends on the way they construe the Act. That is why they consider themselves not bound. So how do they construe the Act so as to exempt them from its operation?
Well, Your Honor is seeing the arguments raised by the DGMC in this case. They're saying that they're not bound by the Act. whether that's a correct view or an erroneous view.
I'm sorry, I'm just trying to understand why. Why is it that they're not bound? That's all.
But isn't it that they are government bodies and not agencies of the government?
Your Honor, I've heard all those. I've heard the arguments and the exchange between the bench and Mr. Ramkuran. The point I wish to make is that if Your Honors do find, which they're entirely open to Your Honor, that the Act does apply to these entities, there is a risk that a lot of contracts, hundreds, perhaps thousands of contracts, will be at risk of being declared unlawful. That's all I'm saying.
Well, but I know what I certainly, for my part, I understand that. But if the law requires us to get to that conclusion, we have no choice.
Yes,
right. So that is why I'm interested in finding out the legal basis on which they suggest the Act isn't binding on them, because that suggestion could be very helpful to us in deciding whether they're right or wrong. But I understand that that is not your within your purview, so that's fine.
Let me ask you something, Mr. Satra.
Sorry, yeah.
Assuming there was non-compliance, that there ought to have been compliance and that there was none, that there was non-compliance. But the proper recourse should have been the one that is set out in the Act. Where should we go from there? What orders should the court make in that event?
Refuse the relief.
Sorry?
The relief claim, that is certiorari, should be refused.
Full stop.
Yes. But that is all he asked for. That is all that was granted. Nothing else was granted. There was nothing to direct that. There was no other relief. No other relief. Unless there are any other questions, that would be all.
Just your thoughts on one thing. You just ended by telling us, of course, that depending on how we decide, this can have implications beyond this case. That is to say, whether or not the Procurement Act applies to not just this entity, but if we declare this entity to be a government agency, then to all similarly circumstanced, what would now be government agencies, i.e. they would all be governed by the Procurement Act, yeah?
Yes, sir.
Would you agree that under administrative review in the legislation, that kind of declaratory order would not be available, and that it is on an application such as this for judicial review that such an interpretation of the law and declaration is what is open, that has, from a public interest point of view, implications not just for this case, but for all, and I'm just using this expression in inverted commas because we haven't said that, and we may not, all government agencies similarly circumstanced, i.e. going forward from such a decision, they would now have to come under the procurement legislation regime, etc., etc. Does that introduce a sufficient public law, public interest element into this litigation to justify this court dealing with it as a public law matter?
This is a contract again. I'm looking at it is the first duty of every tribunal to decide whether it has jurisdiction. So whether the bid protest committee, for example, could entertain a challenge to a contract awarded under the Act. It would have to satisfy itself that the Act applies to the contract or to the tender in question. Has that duty? Because that really is a question of jurisdiction. Whether this Act applies to a tender in respect of which there has been a protest is a question of jurisdiction.
You mean the alternative remedy argument? Is that what you're talking about? Yeah?
Yes, sir.
All right, but what do you do with the Judicial Review Act 2010 section? Let me just see if I could find the section for you. You know that section, there has a specific section in that act. I had it and I cannot find it at the moment. But you know there's a specific section in that act that speaks to, all right, I think I have it here now. Let's just see. That speaks to alternative remedies.
Section 8.
Yeah, but what does it say? Let's just get it here. Yeah, 9. Section 9, right? The court shall not refuse judicial review of a decision where any other written law provides an alternative procedure to question, review, or appeal that decision. So that the Parliament of Guyana has determined that the common law principle of some ancient vintage, I imagine, this doctrine of last resort, that's now overtaken by Section 9. And now I asked the Commission what was their position with the Act, and they said no. They think that this should apply. How do you reconcile that? In other words, this argument is that, you know, if the Act provides, then JR, you say it's a jurisdictional issue, you see. I'm on the jurisdictional issue. You say it's a jurisdictional issue, but Section 9 of the legislation, is it a jurisdictional issue? Is it that this court lacks jurisdiction?
Okay. Your Honor, that Act, it came into operation on the...
I know in 2019, I accept that.
Doesn't have retrospective.
Well, except to say it's very much a codifying act. That's why I keep speaking about the doctrine of last resort. If you follow the common law evolution of that principle, you would see that Section 9 is very much a codifying section in relation to the modern law, administrative law on that point. At least that's my understanding of how that point has evolved. I'm just on a simple question. Do you insist that it's a question of jurisdiction? Or is it that you want to insist on that? Or is it your position really that, listen, as a proportionality point, as a question of discretion, JR is always discretionary, right?
Yes.
It's not that this court doesn't have jurisdiction. It is that in the exercise of your discretion, you ought not to grant the relief because, as opposed to saying that, listen, because jurisdiction means that we can't entertain it. That's all I'm asking.
The particular question, I thought that your question was whether the bid protest committee...
Mr. Satram, you said, I've written it here, the first duty of a tribunal is jurisdiction.
Yes. So
and then you went on.
With whether the tribunal could have dealt with the question which arises with respect to the interpretation or application of Section 2. So what is a procuring entity? And I'm saying that it can. I'm not saying that Your Honor can't deal with that question. Both Your Honors can deal with that question. But the Parliament has provided a remedy in this Act, a complete remedy. The body that has been required to decide these questions is a technical body comprising of technical people to deal with all aspects of procurement. And as a matter of discretion, the remedy judicial review certiorari should have been refused. Because
so, in other words, if I understand you correctly, you're suggesting that the trial court and the Court of Appeal wrongly exercised their discretion to entertain the judicial review proceedings when there were these alternative remedies, these alternative processes available that were not utilized.
Yes,
Is that
sir.
correct?
Yes, sir. Especially when the consequences. You see, the courts below didn't pay any attention to the consequences. Especially when the consequence would have been delaying the execution of the process. You see, that is not something the court could have ignored. And this, the mechanism provided for in the Act, is all geared, it's all designed to avoid this kind of trouble. And it's a technical committee, more equipped.
But tell me something. While it is true that the process that is laid out in the Act has certain timelines, I'm just a tad troubled by the notion that judicial review automatically means greater delay. Now, it has taken 8 years here, and that is substantial delay, and I would acknowledge that. But isn't there a principle that judicial review matters should jump the litigation queue?
And in fact, that's why they're done on affidavit, because the whole point is it's an expedited process in public law. It's a summary process, basically, isn't it?
Yes, sir, all of that is true.
So that
maybe it took time in Guyana.
But if the administrative process had been used, and I must say that I don't know precisely what all of the steps are and how you get from one step to another and so on. But I would imagine, is there a shutout clause in the administrative process? Is the courts shut out from reviewing any step in that administrative process?
It says at 53(6) that the decision shall be final and binding again.
And there are also timelines. You have to do it within, the first protest must be within 5 business days from the publication, right?
And once the contract is awarded,
52(3). Correct?
yes, sir.
But one last thing from my point of view, because you suggested that the tribunal can do certain things. Can this tribunal grant declaratory relief? Can it declare, can it state as a matter of law in rem that a government agency, such as, suppose we reach there, such as GGMC, is, as a matter of law in Guyana, subject to the Procurement Act? Can this administrative review, is that what this is about? Does this have the status? Does anything confer on this? And I think tribunal may be the right word when I look at the composition of this tribunal. Let's use that loosely for now. The status of a superior court of record. Is there any requirement that anyone here should have legal qualifications in the tribunal?
No, but the Attorney General nominates one member of the tribunal.
Nominates one. But does it say, it says here, among professionals who are competent in the field of procurement?
No, sorry, I was talking about the stage after.
Does it say a legal qualification? I'm sorry, I'm happy to be, I didn't see it. Okay.
No, my brother, not at this stage, but at the further stage.
All right, okay, yeah.
Yeah.
So I'm just asking, Because if it is that this JR issue raises an issue as to whether or not, in this case and generally, a government agency, to be defined, is subject to the Procurement Act, is that not something which is particularly within the remit of public law and judicial review?
It would be open, Your Honor, to a litigant to approach the court to construe Section 2 of the Act to determine whether, even outside of a tendering process, to construe whether Section 2, or what is the meaning of Section 2, who it applies.
But stand-in for public law in JR, what is the rule of stand-in? What gives you locus in JR to move the court? The JR Act has it. What's the principle? Who can have locus? Mustn't you be a person or party who is affected? Anyway,
Generally,
that's not
yeah. Not an issue here, but any litigant, a prospective tenderer, for example, can approach the court.
Agreed. Yeah. Okay. But I'm really not on that. I'm really on whether or not the tribunal can grant this kind of in rem declaration or make those kinds of statements that would then have the public law effect that a JR application could promote or prompt.
The committee, bid process committee, can make findings and orders which are binding on the procurement entity and the parties before it. If it is asked to decide whether the entity in question is a procurement entity within the meaning of the act that establishes that committee, I submit that it can do so.
Yeah, okay.
It can. Much of
Okay. Mr. Satram, you are at the end of your time. Is there anything you have to say by way of winding up?
Nothing else, Your Honor. I was hoping to talk much earlier.
Okay, all right. Thank you very much.
Thank you.
We would take a short break now. We'd come back at 11:10, and then we would hear you, Mr. Stobie. So you can take off your cameras and be muted. Bear in mind that if you say stuff, then everyone will hear. But we'll come back at 11:10.
Much better.
Yes.
And I will do a few minutes sweeping up at the end, if it pleases you.
Yes. Very well.
So, and my expectation will be to deal to some extent with the Section 52 issue. I will now mute my microphone and turn off my speaker.
Yes. Mr. Laku, you're on mute.
Yes, good morning to Your Honors, and it's a pleasure as usual to appear before you. Your Honors, I don't want to steal Mr. Stobie's thunder because he will be dealing with this Section 52 issue as to the alternative statutory procedure. But I would just like to point out to Your Honor that the remedy sought in this case was that the award of the contract was ultra vires, bad in law, null and void of no legal effect. Mr. Satram did say that the powers of the commission are wider than the courts. But when Your Honor does look at the regulations which deal with the powers of the commission, in particular Regulation 13, subsection 7, subsection D, at page 117 of the court's record.
What section is that? Sorry, Mr. Laku?
Section 13, subsection 7D. D is in Delta.
And that's the regulation.
Are the regulations. That sets out the powers of the commission, the protest committee. It could be found at page 117, Your Honor. And you will see that one of the powers says this very significantly, that the committee can annul in whole or part an unlawful act or decision by the procuring entity. And these are the important words. Other than any act or decision bringing the procurement contract into force. So if it is that the essential and fundamental challenge is to the award of the contract and bringing that contract into force, the committee does not have the power to annul a contract, a decision by the procuring entity which brings the contract into force. The only way that contract itself can be challenged is by judicial review. Mr. Stobie will deal with that in more detail, Your Honor, but I just wanted to, as that was the last issue raised, I wanted just to advert Your Honor's attention to that regulation. Now, Your Honor, in question of this delay, this is one of the cases arising out of Guyana, which I'm pleased to say that at least up to a certain point, there was no delay. These proceedings, the contract was awarded in July of 2013. The proceedings were filed shortly afterwards, within a month or so. And Justice Chang gave his decision by December of 2013, very promptly, Your Honor. And if it was, as Mr. Ramkran says, that the proper procedure should have been a retendering process and done properly under the Act, why instead of appealing to all the courts up to today, wasn't that process invoked by GGMC? I just raised that point in relation because Your Honors had made the observation how many years past 2013 we're at now. But what is clear, that Justice Chang gave his initial decision within months of the proceedings being filed.
Curiosity, Mr. Laku, when was the Court of Appeal proceedings heard? I don't see it, and determined.
The Court of Appeal these proceedings before this court was brought shortly afterwards. If my recollection is correct, Your Honor, and I speak from memory, I was not involved in the first instance proceedings, but I was involved in the Court of Appeal proceedings, and I think they commenced in 2020 and concluded in 2021.
So Court of Appeal, hold on. Court of Appeal proceedings in 2020?
Is that correct, Robin?
It started in October 2018.
October 2018. Thank you. Yes,
Sorry?
thank you. Yes, quite correct, Ron.
What's the date?
October 2018.
Would you see this as a point? if the decision was given in 2013, you're saying it was given very promptly by Justice Chan, December 2013. Yeah?
Yeah, that is correct, Your Honor. In December of 2013.
Then it was heard by the Court of Appeal 5 years later?
Yeah, Your Honor, for that I can give no excuse. But all I can say that's a fact. And I do not attempt to give such an excuse there, Your Honor, except safe to say, Mr. Ramkrana's very candidly put forward the position that if this process use was wrong, the correct way to deal with it was to retender. Why wasn't that then done in 2013 after the decision of the High Court? If that was the view taken by the advisors to the GGMC. Your Honor, I will ensure that I give Mr. Stobie sufficient time to deal with the areas he's dealing with. Your Honor, our submissions have dealt in some detail with the legal authorities relating to the circumstances in which an agency of the government is a statutory body can be considered to be an agency of the state.
Mr. Locke, stay for the issue which Justice Anderson, I think, raised. We wouldn't need to hear, we don't want to hear you on that. And that issue is if you have any comment on the notion that it is possible for a body to be an agency of the government engaged in procurement, but not be a procuring entity. I don't know if that captured what trouble Justice Anderson.
Yes, Your Honor, I would like to answer that issue this way. The way the court, I respectively submit, should look at the issues before us now is whether in respect of the rehabilitation of the Arimu Road, which was the project in question, in those circumstances was the procuring entity acting as an agency of the state. Because I say this, not every act of the procuring entity will be in its capacity as an agency of the state. I think you would have to look at the facts and circumstances of the specific project, the nature of the project, the functions of the statutory body in respect of that project, and then determine whether in respect of that particular project, the procuring entity was acting as an agency of the state. There's a very short passage, Your Honor, by Justice Bhagwati, which is very...
Before you go there, before you go into detail, and I want to hear you, I had sort of raised that about distinctions of contract. For example, suppose the commission was buying pencils or buying paper. Or, well, I am talking about office supplies, yeah? As opposed to a road or given license for mining minerals. Would you say, therefore, that there are, this is not simply a black and white question, that there may be certain categories of contracts for which the entity, the commission would not have to go through the Procurement Act process? Or is it that for all of its business, it must?
Most certainly, Your Honor, not in respect of every activity of the statutory body are they acting as an agency of the state. There may be many activities which do not attract the provisions of the Procurement Act because by the very nature of those activities, they're not acting as an agency of the government. That means government, not state. And Your Honor is quite right, and I think that that aspect was beautifully addressed by Justice by Justice Bhagwati in Diaram Shetty at page 814. And it is an issue which has been concerning me because it is quite clear that not every activity of a statutory body, the Guyana Geology and Commissions Act readily lends itself to the commission acting as an agency of the state when it performs certain type of public functions, but not all its activities. This is how Justice Bhagwati put it. We may point out here that when we speak of a corporation being an instrumentality or agency of government, we do not mean to suggest that the corporation should be an agent of the government in the sense that whatever it does should be binding on the government. It is not the relationship of principal and agent which is relevant and material, but whether the corporation is an instrumentality of the government in the sense that a part of the governing power of the state is located in the corporation, and though the corporation is acting on its own behalf and not on behalf of the government, its action is really in the nature of state action. This decision dealing with an altogether different point has no bearing on the present issue. So I agree with Your Honor, Justice Jamadar, that certainly not every act of the GGMC would be as an instrumentality or agency of the state. One has to look at the nature of the act, the public content of the act, and the kind of statutory powers that the GGMC was exercising in respect of the particular act in question. That is why, Your Honors, it is very important to look back at the information for bids in this case, which clearly shows that in respect of the Arimu Rehabilitation Project, that GGMC was unquestioningly acting as an agency of the government. Your Honor, I don't want to take you through the entire act because I'm sure I know this court well and I'm sure the court has gone through it. In the invitation for bids, it refers to the national competitive bidding process. It refers to it states that the documents comply with the Procurement Act and regulations, page 139. It speaks of the bidding through the national bidding process as specified in the Procurement Act. And what is very important, the procurement is funded by the government of Guyana, and there are directions by the government as to the tender process. There was an involvement of several government departments, ministries, and projects, as is reflected in one of the reports, which is part of the record at page 131 and 132 of the records. So, Your Honor, when one looks at the nature of the Arimu project, one can readily see the governmental nature of this project, the governmental oversight of this project, and that in respect of this project, it is quite evident and quite clear that GGMC was acting as an agency of the government. Your Honor, I wanted to go on to another area which my learned friend spent some time on, which relates to I'm sorry, Your Honor, I have too many papers on my desk here. which related to whether, Your Honor, the GGMC was substantially responsive, whether CB&R was substantially responsive to the bidding procedures as set out in the information for bids. Your Honor, it is submitted that CB&R never qualified for consideration in respect of the award of this tender. At Section 39(2) of the Procurement Act, the evaluation committee may only use evaluation criteria which is set out in the tender documents. And a tender could only be considered to be responsive if it conforms with the requirements of the tender documents, minor deviations apart. Those are the requirements of the Act itself. And what is most important, Your Honor, is Section 39(5) of the Procurement Act, which states that a tender shall be rejected if a contractor that submits the tender is not qualified. So one must then, Your Honor, determine, you see, Your Honor, my learned friend, Mr. Satram, adverted, Your Honor, to Section 27(1) of the tender documents, which can be found at page 158 of the record, and dealt with what were substantially responsive bids. But what Mr. Satram did not avert Your Honor's attention to was Section 32(1), which can be found at page 160 of the record. And if I may read Section 32(1), because it's very important in addressing the issue as to how the CB&R bid should have been approached. Subject to the information to bids clause 33, the employee shall award the contract to the bidder whose bid has been determined to be substantially responsive to the bidding documents and who has offered the lowest evaluated bid price. Provided that, and these are the important words, Your Honor, provided that such bidder has been determined to be A, eligible in accordance with the provisions of the ITV, clause 4, and B, is qualified in accordance with the provisions of the ITV, clause 5. So the question of substantive responsiveness, Your Honors, only applies after you have determined the issue as to whether the bidder, and the bid challenge in this case is the bid of CB&R, has qualified in accordance with the qualification provisions in the bids, which are set out at the record, page 159, 5.38 to J. Page 149, sorry, Your Honor. That sets out the qualification requirements. And Your Honor, one must read the provision I have just read in the light of the qualification provisions, because the question of substantial responsiveness doesn't arise until you first of all have qualified. The words provided that are very important there, Your Honor. And in relation to the qualification of CB&R, it is respectfully submitted that they provided no information whatever. And this point was raised from the inception of the notice of motion brought by BK International. They have provided no evidence of qualification of any of the criteria mandated in clauses 5.3a to j, which qualifications, I might add, Your Honors, mirror the criteria set out in Section 5 of the Procurement Act. The words provided a bidder is qualified is the first criteria that ought to have been addressed by the procuring entity before the procuring entity even went into the issue of substantive responsiveness. So if it is, Your Honor, that confronted in the affidavit which set out in detail the body which investigated the bidding documents and the information submitted, if that criteria is not complied with in the context of qualification, it is not even necessary or permissible to go to the issue of whether there was substantial compliance with the other tender documents. And CB&R or Chunilal Babulal, whichever one it was, because a different person was awarded the contract from the person who bid. And up to now, there's no evidence before the court of any link between the two. But Mr. Stobie will deal with that separately. If it is that no evidence has been provided by CB&R or by GGMC as to the requirements of qualification, then, Your Honor, we'll have to move to the underarching provision in the Procurement Act, which is Section 39, subsection 5. We're not dealing now, Your Honors, with substantial responsiveness. We're dealing with qualification. You have to qualify before the question of substantial responsiveness even arises. And what does Section 39(5) of the Procurement Act state? A tender shall be rejected if a contract that submits, if a contractor that submits the tender is not qualified. So if that person who submits the tender is not qualified, you don't even, substantive responsiveness doesn't even arise. It's not relevant. If you haven't qualified, that's an end of the matter.
I think we understand that point, I think. I certainly do. Can you say in what respect specifically that Mr. Babulal didn't qualify?
The criteria of qualification, Your Honor, is set out in the invitation for bids from page 149 of the record. And it's set out in subsections 149 5.3 A to J.
Sorry, what you said, you went up too fast. Qualifications are set out where?
In the invitation for bids.
Okay.
Clause 5.3, which can be found from pages 149 to 149A, Your Honor, to 150J of the record.
Okay.
There are a number of qualifications going from A to J.
Okay.
Which have to be provided before a bidder can qualify.
So are you saying that none of those was satisfied?
Absolutely none. Not one of them, Your Honor.
Are you saying that none of them was satisfied, or that you have no evidence that any of them was satisfied?
Well, Your Honor, one of those one leads to another, Your Honor. This is a court which is dealing with evidence before the court and not what ought to have been before the court. And when in the notice of motion the issue of qualification was raised, and when in the notice of motion the applicant set out all the areas which he claimed, and this was after there had been an inquiry entered into by an independent organization, which has not been challenged, and which set out in detail and which can be found, Your Honor, in the page 115 of the record, if it pleases Your Honor, because Your Honor is now touching the key elements of this case, if I say so with respect. And Your Honor, you will see that it was set out in detail, all the requirements which were set out at 115 and then again at page 202 of the record. All the requirements which were to be complied with, to comply with the information for bids. And you will see that under the column CB&R mining, there is absolute and total non-compliance, which would have rendered CB&R capable of qualification for the award of this contract. Absolutely not one was answered. What the independent investigating committee did was analyze the bids of all the bidders and showed what was required under the invitation for bids under 5.3 and what was provided. And you will see, Your Honor, that CB&R provided nothing. It is quite obvious, and Your Honor, I say so, I don't mean to make any comments adverse to anyone, but it gives one the impression that CB&R had been pre-qualified in its broadest sense even before the tender was considered. Because how could you be considered and awarded a contract when you have not even complied with one singular item which is required in the
Mr. Lucko, does the 5.3 start with if the employer has not undertaken pre-qualification of potential bidders? So you are saying to us that the employer did not undertake pre-qualification of potential bidders. Is there evidence of that?
There is no evidence that there was any pre-qualification proceedings. Your Honor, pre-qualification proceedings do not take place by a person asserting they have taken place. It requires compliance with the Procurement Act, Section 6. Section 6 sets out the circumstances and requirements of pre-qualification.
The Justice Chang find as a fact that no pre-qualification process had taken place?
Yes, Your Honor, and Justice Chang dealt with it at some length. He addressed this in great detail and said if they did take place, it was a mystery. I remember those words. I can't, they're indelibly entrenched in my mind, Your Honor. If any pre-qualification process did take place, it was a mystery because nobody has told us anything about it. Your Honor, let me try and find the...
No, I remember that passage. And what do you say to the notion that there was no compulsion on the GMMC to engage in a pre-qualification process?
Your Honor, let me answer that question this way. If you engage in a pre-qualification process, the Procurement Act sets out a specific procedure which must be adhered to, which starts at Section 6 of the Act. And it involves a very complex procedure, I wouldn't say complex, a very detailed procedure relating to invitations to qualify, a request for pre-qualification documents, which shall include certain documents which are set out in Section 6.
Yeah.
And then
is there any compulsion on them to undertake that process? Suppose they didn't have the process. Does that automatically mean that the whole process was flawed?
Well, it would seem so, because, Your Honor, there's another section in the Act which deals, if I may advert Your Honor's attention to a very relevant section, Section 26, which deals with something I think which Your Honor has in mind, but they call it restricted tendering, where due to the expertise of certain, I suppose, contracting or construction companies, you don't wish to engage in a whole pre-qualification process, but you can engage in what is known as restrictive tendering under Section 26(1), where you can invite suitably qualified tenderers to submit tenders. Now, I think that is the kind of situation Your Honor has in mind. There's a little bit of a hurry to get this done, and therefore you can invite people who you consider, or the GGMC considers, appropriate persons to submit tenders for this particular project. But Your Honor, there's a problem they have there why this section could not have applied, because this section refers to, before you can invoke this section, Your Honor, if I may read Section 26 of Section 2, because it's a very important aspect Your Honor has raised. When they call it restricted tendering. When the restricting tendering process is used, only suppliers or contractors invited by the procuring entity, due to their qualifications, can submit tenders. All other steps and requirements applicable to open tendering set forth in Part 5 of this Act shall be complied with. Now, Your Honor, when one looks to the regulations, it is necessary now, Your Honor, to look at the regulations as to the criteria in respect of which the criteria in respect of which you can invoke this procedure of restricted tendering. And Your Honor, if you would be so kind as to look at page 121 of the record in Appeal 003, that is Mr. Satram's record, where he has set out in detail, very conveniently for us to address all the relevant legislation. That is the section which relates to restrictive tendering, where you can invite tenders without pre-qualification process. But there's a problem here why this could not be invoked in this specific case, because there's a threshold which is set out in Schedule 2. The threshold foreseen in Section 26(1)(b) of the Act, that is the section which dealt with restrictive tendering. For the use of restrictive tendering method of procurement shall be $1 million in the case of contracts for goods and services other than consulting services, and $5 million in the case of contracts for construction. Now, this contract could not have qualified under the concept of restrictive tendering, because when you look at the engineer's estimate for this contract, it was in excess of $300 million. So,
sorry, it's in the schedule. What currency is that?
Oh, Guyana. We only speak in Guyana dollars when we speak with so many knots, Your Honor. Jamaica's pretty close to that. Well, Your Honor, that's at page 121. It's all Guyana. Pardon? And Your Honor, you see, that is why they couldn't use restrictive tendering here, because it was outside of the statutory parameters for restrictive tendering under Section 26. And if they wanted to use pre-qualification, they could have done so perhaps, but they would have had to adhere to the pre-qualification process, which is set out in the Procurement Act, and they never did that. And Justice Chang has dealt with that, Your Honor, in great detail in his decision. Yes, please, Your Honor.
Did you or your client protest the process which had been used, which apparently also saw your client pre-qualified in the same way that the other side was pre-qualified?
We weren't pre-qualified, Your Honor. If you look at our client's notice of motion, we were invited. That is different than pre-qualifying. The pre-qualification is used in these proceedings now by the appellants. We never use pre-qualification. We are not, my client is a contractor. He doesn't know law. He doesn't know the procedure under the Procurement Act. He is relying on those entities which invoke procurement to adhere to the law. And I think he's entitled so to do, Your Honor. It is not for him to know whether he's qualified as our people.
Mr. Babulal would have done the same thing, save that you are suggesting that that was not the right thing that the GGMC did. Am I correct?
You're quite correct, Your Honor. But Your Honor, you know what? I was trying to avoid saying this. But the mere fact that Mr. Babulal did not submit any qualification criteria, I don't know if that could lead to a reasonable or unreasonable inference that he expected to be chosen. You see, Your Honor, when you look at the evaluation committees and their reports, and Your Honor, I'm not going to have enough time to go into all these things, but they're there, I think, in outline in our submissions at one point or another. Your Honor, I want to make this point, though. The evaluation committee of the GGMC comprised all the members of the GGMC. I don't think that is right, or largely so. None of them signed any of the evaluation reports. Not one of them has appended a signature to it. And they have used criteria in those reports which are completely wrong and bad in law. They have used criteria such as the use of the RMO road by CB&R, the vested interest in the RMO road by CB&R. Your Honor, it was quite wrong to use those kind of criteria.
For public law, would you say that those were irrelevant considerations?
And extraneous.
And extra, okay.
Yes, quite so, Your Honor.
Mr. Lafu, before you move on,
yes, Your Honor.
The matter of BK benefiting from being invited and the disentitlement of CB&R to similarly benefit from being invited?
Well, Your Honor, BK was invited, but right. BK provided all, or to a large extent, there are only 2 items he did not provide in the qualification requirements. BK provided all the information in the qualification requirements, which are set out in clause 5 of the information for bids. And you will see that in the report of the...
If you are correct that this had to follow the section 6 procedure, because the section 26(1) procedure did not apply, if you are correct in that, and if you are correct that GGMC did not follow that, then is it not a matter of legal integrity that if the decision is quashed, no one should be the beneficiary, not your client either, and that the process, the correct, in other words, in public law, that sounds as a substantive procedural irregularity.
Yeah, Your Honor is entirely correct, and I think that is why Justice Chang was correct in not awarding the contract to BK.
So therefore, your client, I thought for a moment in answer to our brother Justice Baru, you were suggesting that your client had some, I don't want to say past, but was the beneficiary because he does not a lawyer and et cetera, and he was invited. But it must be that it cuts both ways and all ways, if you're right.
Right, Your Honor, I think I will have to agree with you. I cannot disagree with that approach.
Right.
If it is that the process invoked was a wrong process, no one can benefit from it.
The process that may have to be restarted.
It will have to be. But what I do say, Your Honor, there is by no stretch of the imagination or the contract in the context of this case. When you look at fairness of procedure, compliance with procedure, the principles of public law, could this contract have been awarded to CB&R? That I say without reservation.
Yes, well, counsel, this is the point. Hold on. This is where you have gone off from what I was asking. BK provided all the info. You have just told my brother Jamadar that did not, however, entitle them any more than CB&R to be awarded the contract. Is that correct?
No. Your Honor, maybe I put it over very badly. Let me put it this way. What Justice Chang decided was that he would not grant the order of mandamus that BK be awarded the contract.
Right.
But he quashed the decision to award the contract to CB&R.
Work with me.
Yes.
If he had awarded the contract to BK based upon, if the employer had awarded the contract to BK based upon what they furnished, could CB&R have equally said that they did not pre-qualify?
No, Your Honor, for this reason, that the responses to the invitations by BK were, apart from one item, I think it is that he did not respond to, which is de minimis, was substantial, sufficiently substantial for him to have been awarded the contract. When you look at the comparative analysis by the independent consulting body who compared the information provided by the three bidding entities, you will see that CB&R complied with nothing. BK complied with everything, I think, except two items, I'm corrected. And M and CC complied with the majority of the items. So I think, Your Honor, let me put it this way. If Justice Chang had chosen to make an award mandamus to award the contract to BK, I would have submitted that decision would have been correct, but we haven't cross-appealed in that, so that does not arise in this case. The only issue in this case is whether the award of the contract to an entity which hasn't even proved he's a legal entity, who he is not qualified with any of the qualification requirements, who has not provided any information justifying qualification, whether that decision in the context of this case should be upheld. I submit respectfully that is the key issue for the court to address.
Thank you.
Your Honor, I want to leave some time for Mr. Stobie. There's so many more areas I have liked to have gone into, but maybe I erred when we were setting up the timetable because there were two appellants, and I don't know if we should not have had an equivalent quantification of time in response equal to both of the appellants added together. But I never asked for it, and what you don't ask for, you don't get, Your Honor.
I am glad you remember.
Your Honor, I will pass over now to Mr. Stobie to deal with an area which I had touched on because I touched on what I consider an important point, because the limited powers of the committee, if we had gone to them instead of coming to you, the courts, Your Honor, which I maintain in a case such as this is the appropriate body to exercise jurisdiction. I'll hand over now to Mr. Stobie, and I thank you very much, Your Honors, for your patience. It's always a pleasure to appear before you.
Yes, thank you. Mr. Stobie. You're muted, Mr. Stobie.
You got it, Ellen.
We are not hearing you, Mr. Stobie. You are muted.
Yes, please, Your Honor. I was just trying to be heard. I would like to take up from where Mr. Laku ended off, and I would like to draw the court's attention to paragraph 28 of the decision by the Court of Appeal, which is at page 23 of the record. And why I draw attention to that is because I think that is the crux of the matter. The crux of the matter is, as the Court of Appeal pointed out, that the person to whom the contract was awarded was not a person who tendered for the contract. The person to who received the benefit of the procurement was a person unknown to the procurement process. My friend is very helpfully included for our purposes, my friend Satcham, very helpfully included for our purposes in his submission, information which corroborates our which corroborates what I've just said, and I think that is contained in his submissions in reply at pages 1020 to 10. Just 1 minute. The 1023, where Your Honor will see that I will call it the organization that was in fact the tenderer was CB&R Mining Enterprise. And CB&R Mining Enterprise, to all intents and purposes, is a partnership between Babulal and Ramnarain. So that when the contract was awarded to Babulal and not awarded to Babulal and Ramnarain, it means that it was in fact awarded to somebody who did not even pretend to be the person who had made the original bid. Now, Your Honor, those are matters which I would respectfully submit make it difficult for there to have been any consideration under section 52 of the Act, whereby my friends have been submitting that we should have gone to the bid protest. Now, the bid protest is divided into two aspects. You have the aspect at just 1 minute, please. Let me try and find the Act. If you look at in the regulations, if you look at regulation 10, and I'm reading from 10 going on to 11, which is at page 113 and 114, you will see that there's two aspects. One, regulation 10.4 says, if procurement proceedings have not led to an effective contract, then certain things take place. And then regulation 10.5 says, if procurement proceedings have already led to an effective contract, the complaint may complain directly to the bid protest committee. But as my friend Laku has already pointed out, the restrictions on the powers of the committee are to the extent that they are not capable of doing anything such as annulling, such as rescinding, such as taking any action which will cause a contract that has already been awarded to be brought to an end. So their point of procedure is limited, and this is principally a case where the contract ought not to have been awarded to Mr. Babulal, because, as I've already said, Mr. Babulal was not a person who was entitled to have the contract awarded to him, apart from any questions or considerations of qualification which my friend has dealt with. So the appropriate procedure was not, in fact, to go to this protest. But I pause just for a minute to say this and to draw attention to certain features of this case, and particularly the evidence that is before Your Honors. Your Honors will note, for example, that the tender was, we presume, was sent out. I don't know in what fashion it was. It's a bit difficult to understand because our client in his motion says at paragraph 4, page 100, that in or around the month of June 2013, the Geology and Mines Commission invited bids by publication. Well, it's not really that clear what that means. But in any event, that was on the 11th of June 2013. Now, according to the date when the tender should have been chosen, that date should have been by the 25th of June, according to the requirements for the choosing of the date for the tender. That was not done. What next took place, from what I can understand of the proceedings, was the chronology, was that there was a letter of acceptance of Chunilal Babulal in respect of the tender, Chunilal Babulal, on the 16th of July. So this is nearly a month later. There was an agreement with Babulal, either on the 20th, well, I think that Mr. Dennison was incorrect in page 245 to say the 189, sorry, to say the 21st of June. Babulal says the agreement was on the 19th of July. And Babulal's agreement, I think, is at page 242, if my memory serves me correct, of the record. Just 1 minute, John. I'm going to try and find page 242.
Yes, 242.
Page 242 of the record, where a document is put forward which states that it is an agreement. It's apparently signed and it's apparently dated the 19th day of July 2013. It does not, in fact, say who the contractor is at the head of the document, but it seems to be signed by Babulal. That is the date when the agreement was apparently signed with him. And in the space of...
Mr. Slovi, can you just tell me, so it doesn't have a parties clause? The agreement does not have this agreement made between A and B?
This agreement made on such and such a date between the Guyana Geology and Mines Commission, I'm reading, here now to call employer.
Of the one part, no doubt.
And then the contractor, the other part.
I know, but who's the contractor? But at the bottom, is the signature?
At the bottom, it has Mr. Babulal. I presume it's Mr. Babulal signing.
Is there a jurat?
No.
That says signed by?
No.
No. Signed, sealed, and delivered by the said blank in the presence of Chairman Board of Directors,
Okay,
Guyana
no. Right, okay.
So that is as far as they go. Well, we are making the assumption that this is the agreement which Mr. Babulal entered into. And we're making the assumption that if that is so, then the agreement was signed on the 19th of July. And I think that is a date which is but 3 days before the minister on the 22nd of July says to GGMC, don't proceed further. That's Exhibit D. And I think Exhibit D is at page 127 of the record. And if we look at page 127 of the record, we'll see that the minister's terminology.
114.
114. I think it's also 127. It is at 127 and 114. This is what the minister says on the second paragraph. He states there has been a complaint by BK. He states that in the light of the above mentioned, the ministry is kindly requesting the urgent investigation into the matter before the commencement or continuation of any said works. That phraseology tends to suggest that the minister himself did not know that there had been an award of contract, much less BK. Neither of them would have known at that date that a contract had been awarded.
What was the language? Before what? Sorry?
Before the commencement or continuation of any said works.
But works?
Yes.
Okay.
And in fact, the contract with Babulal, I have not been able to find any evidence on the record that shows that it was published. So that would in fact cause some difficulty, even if one wanted to insist that there should have been a following of section 52. How would BK have known that the contract had been published when there's no evidence?
So before, just sorry, on a question of fact, before you come to publication, so that the minister writes, what date is this?
The 22nd of July.
Right, so 19 from 22nd.
3 days.
Yeah, 3 days. But the contract went ahead.
Yeah.
That is exactly the point. The contract, this minister's letter was totally ignored.
In defiance.
And I might also add in defiance of the minister, because it is quite clear that the commencement order was made on the 5th of August, 14 days after the minister's letter.
By?
And before.
No,
that,
who gave that commencement directive? GGMC?
GGMC at page 189 and 193 of the record. 189, I think, is a reference to it.
When did GGMC give the commencement order? What date, sorry?
The 5th of August. Well, yes, the 5th of August, Your Honor. Page 189, paragraph 2 of Denison. Supplementary affidavit. And then in a memorandum at page 193, it's referred to again, a memorandum signed by one called Richard. Commencement order for the project instructed the start of works on the 5th of August. So you had all of this activity, which appears to be unknown to anybody. This is done.
Can we pause at the recount of the activities, because I'm curious about this. Is there power in the minister to stop the commencement or continuation of the works outside of the administrative review procedure, which, as you know, escalates from the procuring entity to the commission and to cabinet? Can the minister on his own, ignoring that procedure, simply direct the procuring entity not to permit the commencement or continuation of works?
Section 30.
Well, section 30 of the Act would
GGMC
seem, that is to say, the GGMC Act.
31.
Sorry. Let me find that. Section 31 of the GGMC Act. Let me see if I can find the exact page number.
It's there. It starts.
States this: the minister may give to the commission directions of a general character as the policy to be followed by the commission in the performance of its functions, and the commission shall give effect to those directions. I would want to submit that you certainly don't, it would not be in the interest of the commission to have disregarded the letter of the commission.
Sorry, with respect, I'm not concerned with the interest of the commission.
Very
I'm
right.
concerned with the lawfulness of the minister to give a specific direction in relation to a specific contract that they should not commence or continue. And certainly what you read just now about giving general directions, I don't think, as the policy, I don't think that covers it, do you?
Well, I would want to say, Your Honor, that if the general directions includes how they should proceed in a general method in relation to what is an important function.
Sorry, what Council says general directions as to the policy to be followed.
Yes, please. Well, that is what I respectfully submit is being in fact done by the minister. The minister is saying, do not proceed with this particular.
That's not a policy directive. No stretch.
Well, it's a directive I would respectfully submit that encourages the GGMC to be careful in their consideration, because what is required is that let us investigate what is being complained about.
It does not get you over, in my view, but I quite like the phrasing.
That's good for you.
Not to go back too much to the Jamaican experience, Mr. Stobie. I know you're very familiar with it, but you know there are cases in Jamaica where this issue has come up, and in particular in relation to public utilities, and it has been held quite clearly that the minister cannot give the kind of specific directive as regards operational matters, as seem to be what you're arguing here. The minister can give and is completely intended to give directions of a general policy nature, but that's very, very different from instructing operations on a particular contract.
I think the point that I was trying to make, is several-fold, not least that GGMC falls under the direction of the minister. But what I'm trying to say is that you have this situation that is developed, which particularly pertains to whether or not BK could have instituted a process under Section 52 or ought to have instituted a process under Section 52. And the point I was trying to put forward is that he did not know that there had been an extreme extent of which the contract had in fact developed to the point not only of being signed, but also of being commenced.
And I believe under this section, he had 5 days, didn't he, Mr. Stobie? If you look at the review thing, if we look at he had 5 days from the date of the decision, is that not right?
That is quite correct, Your Honor. But there's no evidence as to when the decision was available to him.
Yes, I am very sympathetic to that. And in fact, the trigger point is the publication of the contract.
That is quite correct, Your Honor.
So was this contract published?
No. Not to the best of my understanding, from the evidence that appeared before the learned Chief Justice. But that was a point. That was a point that perhaps ought to have been in the court of GGMC, rather than GGMC denying every single paragraph of the motion. They should at least have done something positive and told us something or when this was done, but they didn't.
Yes, well, yeah, it's problematic for them too, because what they're saying is that their activity did not fall under the Act. And therefore, if it did not fall under the Act, then there's no requirement for the publication of the contract.
Indeed. I think that is
on the other hand, I think they're also saying that this alternative to challenging the process could have been engaged in. At least Mr. Babilal is saying that. But how can you engage the process if there's no publication of the contract? So there's that difficulty, yeah.
This is why we argue that it was not unreasonable, or it was not
more effective,
unusual, or it was not less effective for BK to have gone to judicial review. After all, we did not expect that judicial review would have taken such a long time. We ourselves had an interest to serve in having judicial review done quickly, in having the questions concerning the contract done quickly.
Just help me with the timeline now, because you've done a chronology which is helpful. So the commencement order, I'm just looking for the note I made now. The commencement order was when? The 5th of August. 5th of August, right.
2013.
Good, right? Fine, thanks. When did the, BK commence the JR proceedings?
BK commenced GR proceedings from what I can see.
First of all, you have to have the investigation.
September 16th.
13th, I think, actually. 13th of September.
The Court of
That's the
Appeal
date.
says September 16th they filed the writ.
Oh, I see they have a stamp for September the 16th.
Did they have to go for leave first and then
No.
issue the, no? So it's
No, this
September.
is the old-fashioned form.
Right, okay, good, no problem, yeah. And when did they review? Because they wrote a letter. Because one of the things about JR, as you may know, is that timeliness is something, right? So this is, as for me, I'm curious about this. They wrote the minister. The commencement is the 5th of August. Within, the usual standard for JR is 3 months. Within the commencement of 5th of August. Do you know when works actually started, since there was no notification? And is there any evidence of that?
No evidence.
There is no evidence of that. There is some statement by Dennison in his supplementary affidavit, in which he asked that the payment be made to Babalal of the sum of money, in fact, the exact sum of money that the Chief Justice awarded on a quantum merit. If you look at page 189 and 190.
I'm not interested in the quantum. I'm just interested in the chronology for the purposes of JR.
Very well, Your Honor. Well, what seems to have taken place is that work commenced sometime soon after the 5th of August.
Okay.
And he says at paragraph 3 on page 189 that it continued until the 19th of September 2013. That is what he states there. And then the filing of the motion, there was no further work. So I understand this to mean that there was a month between the commencement order and the stopping of the work. And of course, in the meantime, that motion was filed. So it was filed within that month period.
And the review that was undertaken, when was that?
The review
was completed?
I have as my understanding that the review at page 202.
This is the ministerial review, right? This is the minister.
This is a review on behalf of the minister. At page 202, it seems to be August the 9th, unless I'm reading wrongly. That seems to be the date when the letter from SEMCO was sent to the minister. So you have August the 9th, and you have the filing of the notice of motion on the 16th, as we have now discovered, the 16th of September. So in just over a month, the motion was filed to seek to have a review of this matter by the court.
And up to this time, at least up to the 16th of September, no decision was published or notified to your client?
No.
No, okay, right.
At least let me be fair. Let me say, as far as I'm aware, there is none on the record.
Well, I'm interested in your client knowing.
No, we have never received any notification. Yeah. We haven't even received a notification that he was rejected, which would have been the right thing to do. So we respectfully submit that perhaps the clause that is important to consider in this is the clause in section 52, which speaks of the complainant may make a complaint, not must. May make a complaint to the procuring entity. I seem to have lost that clause for a minute, but I think it's section 52.
52(1) may submit a written protest.
Yes, it doesn't seem to have that degree of how should I put it? declaratory nature that is required to do so. So, Your Honor, the
Mr. Stobie,
yes,
I wouldn't push that point myself if I were you.
right.
The May speaks to the point that you don't have to complain.
No, you don't have to complain.
So you may complain.
You may complain, I agree.
It could have been phrased in the other way. A person who has a complaint shall file within 5 days. That's not what is here.
That would have been a preferable form of drafting.
I'm sure you would have preferred it. So let's move on.
Yes, please, Yana.
But you see, I mean, the problem is obviously as a question of fact and law. 52.3 says you must file within 52 days following publication of the contract award decision. And what you are telling us as an uncontroverted fact, that was never done. And therefore, as a question of fact and law, BK could not comply with 52 because 52 is triggered by
the publication.
3. Is that not your argument on this?
That is indeed.
Yeah.
How and when did BK become aware that the contract had been awarded to Mr. Babulal?
That's not very clear in the proceedings, Yana, and you will have to bear with us because we were not the original counsel in this matter. But I would, all that I can say is I would assume that in or around the date of the judicial review is when he became aware of it, and that triggered the judicial review proceedings.
Mr. Stobie, it may be since they complained to the minister at some much earlier stage that they knew that they had something to complain about.
Or they may have suspected. Or they may, or worse yet, they may have actually seen the work on the ground at some stage. That is probably true. I would be inclined to agree to say that sometime after August, they probably knew that there was something going on there which ought not to be going on. Mr. Babulal was there and not Mr. CB and R Mining. And they probably knew that. But it is our continued viewpoint, please, Your Honor, is that in the circumstances of this particular case, judicial review is appropriate. And the nature of the declaration sought, the declaration sought was not accorded in favor of BK. So he is bound by the fact that what the Chief Justice determined means that the entire process was brought to stop. And that is where the matter lies as far as I understand it at this stage. I don't know whether there's anything further that Your Honors would wish to hear from me on this point.
Yes, okay, thank you.
So, sorry, Mr. Loku, then, correct me if I'm wrong, but there doesn't seem to be that much difference between you and the other side, is there? In terms of the ultimate result.
Your Honor, the process of unmuting is more difficult for me than the process of understanding the procedure of GGMC. I'm sorry, Your Honor, could you be so kind as to repeat that?
No, I'm just wondering, and maybe I missed something. There doesn't seem to be that much difference in the result that both sides would want in this case. You both want to unscramble and start all over again, isn't that so?
No. Your Honor, I'm so sorry. I unmuted but didn't turn on the volume. I'm still in the Jurassic development of the computerization systems, Ron. My daughter has to be close by.
Yes, well, I'm sure you're glad that she's close by. No, I was just saying that I'm wondering if there's that much difference between both sides as regards the viable remedy that could be offered in this case. Because aren't you both saying, well, we are prepared to go back to the drawing board and have the correct procedure for it?
Your Honor, I understood that for the first time when I heard Mr. Ramkaran's statement before this court this morning, and which I think is a very fair statement. That is not the position taken by Mr. I don't know if I must call him Mr. CBNR or Mr. Chunilal Babulal, because it seems to be a schizophrenic situation, Your Honor. But Your Honor, the position taken by Mr. Ramkran this morning, I think, is the correct procedure. That if, you see, the court has not awarded us mandamus to be awarded the contract, and we have not cross-appealed. So that is not open to us now. So, Your Honor, I think Mr. Ramkran's suggestion, and it seems to me, quite frankly, that this procedure was entirely flawed from the beginning and cannot stand the scrutiny of this court. It ought not, so let me put it another way, it ought not to stand the scrutiny of this court. And insofar as Mr. Ramkran's position is that the correct thing to do would be to reopen the tendering bids, I think that is a very equitable position. As a matter of fact, I think that is the position that Justice Chang saw it as. If you,
Mr. Laku, except to say, Mr. Ramkran does not concede that the commission is governed by the procurement regime.
Well, Your Honor, let me put my statement another way. Assuming that the commission was governed by the Procurement Act in the circumstances of this case, and I say so in the circumstances of this case, I think his observation, let me not use the word suggestion, his observation that the most equitable way forward would be to start the process properly once more from the inception is the correct one. That is not the position taken by Mr. Satram, who says that the order should never have been made to quash the contract at all, and his contract notwithstanding, his client was never ever qualified, it should still be granted to him. But that is...
Let's hear from Mr. Ramkran himself, and maybe he's best positioned to
say what he said.
What the position of the commission is. Mr. Ramkran, we'll give you 10 minutes because I want to give Mr. Satram some time as well.
Hold on, what do you do now?
Thank you, Your Honor. Your Honor, the last bit that has been stated by my learned senior, Mr. Laku, is essentially the position. We're maintaining our challenge to the GGMC being caught under the Procurement Act, but we are willing. We are not challenging any other aspect in any material way. I apologize for the equivocal language, but this is essentially what it is. If the court orders that that the process be the tendering process be reinstituted or restarted, we are happy to comply. We're required to, of course, but we are happy to proceed along that direction.
Just one question of fact, Mr. Rambaran. Was the contract awarded to Babylal or CBR? Was it ever published?
Not that I'm aware of, sir. The proceedings, the challenge to the proceedings took place very shortly after. I'm not sure what the timeline ordinarily is for publication, but if it had been done, I am sure this would have been brought into the evidence of Mr. Dennison, and I did not see it, so I assume it was not done.
But you would agree that that's another flaw in the process, because to the extent that we are saying that 52, 53 represent an avenue for challenge, that avenue can only be walked at the point when there is publication of the contract, yeah?
Well, it appears that the commencement order was on the 5th of August. I would say that any publication that should have been made prior to that date. I'm not aware that it was done.
Okay.
Okay. Is there anything further that you wish to advance, Mr. Ramkran?
No, please, Your Honors. I have listened to my learned seniors, and I believe that any issues that I wish to have raised were raised by the court already.
Yes. Okay. Thank you. Mr. Satram?
Your Honor, just on a small point of evidence, at paragraph 32 of the affidavit in support of the motion at page 106. The case says that that having not received any notice on the 22nd of July, and having learned that CB&R Mining was awarded the contract, we did approach the minister, etc. So that is the only evidence I was able to find to suggest when he became aware that CB&R was awarded the contract. At least in
what page is that, Mr. Safran?
It's 106.
106. Could you just read that just for my benefit again? What did they say? Have I not received what?
Any notice on the 22nd of July 2013, and having learned that CB&R Mining was awarded the contract, I approached the minister. Paragraph 32.
Thank you.
Your Honor, I don't wish to add anything more.
Yes, okay.
No, sorry, but I wanted to ask you one question, please, Mr. Safran. Do you concede that if your client was not qualified, the contract could not lawfully have been awarded to your client?
Your Honor, I've heard what the distinction Mr. Lockwood is trying to make, but I don't see that there's any difference between being qualified and being responsive. You know, the being responsive is what entitles you to be considered, and that is governed by Clause 28 or whatever it is we discussed earlier. Being responsive and being qualified, more or less the same thing.
Oh, so you don't see a distinction? Because Mr. Lockwood was very clear there was one, and that qualification was a precondition to considering responsiveness.
I understood him to be saying so.
Okay, thank you.
Absolutely.
Yes, okay, thank you. All right, so we are grateful for these submissions. Mr. Stobie and Mr. Lucky, we don't need to get back to you. You already have indicated your submissions, and there has been little or no response, which I think that you need to respond to. So that at this point, I think I would simply indicate that we will naturally take time for our decision in this matter. And when it is ready, we shall certainly let you know. So I would ask the registrar, the deputy registrar at this point, is to close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt, Mr. Justice Anderson, Mr. Justice Barrow, and Mr. Justice Chamada. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good afternoon to all. Thank you very much.
Good afternoon.
Good afternoon.